agency, because you cannot believe what we're seeing on contracts, number one, and number two, we've got people in trouble because agency is not being done correctly. So, who can give me a basic idea of what agency is in a contract?
It's fiduciary responsibility to the person you're representing, as well as the seller.
To disclose things that are within a diligent, that paragraph.
Okay. Anybody else want to give it a try?
I think we both get asked.
Huh?
It must be wrong.
We know the paragraph.
Basically, it shows that you represent the buyer or the seller of what you said.
Well, that's closer. There's two parts of agency. One is disclosure, and one is confirmation. So who can tell me the difference between the two?
Confirmation means that it's
It does.
They're a trick question.
This is like
Now, see, what's really interesting, I'm looking at blank faces. It's like, my God, real estate 101.
Wow, we're only doing it because we know you got a trick question.
No. And they're serious questions because it's not happening. I'll tell you why it's not happening. I got filed a check the other day that has closed, and agency wasn't signed. I got another file to check. The listing agent had his agency with the seller, but had nothing in the file about the agency with the buyer's agent and the buyer. So I'll go back again to agency. Agency is broken down into two parts. One is disclosure, one is confirmation. So let's talk about disclosure. Two distinct parts to agency. Agency by law and disclosure by California Civil Code is where you provide to the seller and or the buyer the information that's already been pre-printed for us, telling them about fiduciary responsibility and the right to be represented, and to the other party, fair and honest dealings. So let's talk about that for a second before we get into the forms. If I am the listing agent and I represent Mr. Hiller as the seller, I have a fiduciary responsibility to him, correct? Explain fiduciary, very simple to me, somebody. Legal's part, but if you were asked by the Department of Real Estate, Betty, to tell me what fiduciary means to you and represent me as your seller, what would you tell them that your responsibility to me as the seller under fiduciary is?
I just retired.
Duty to disclose all facts known to materially affecting desirability of the property or with the diligent attention of all parties.
That's to the buyer.
And seller.
And it applies to the seller, but fiduciary is a step beyond that. Your fiduciary responsibility to the seller includes but is not limited to everything that you should or should have known or could know based on your license, your time and experience, representing and disclosure to the seller. It is the highest standard that you are held to under the law. And if you are representing the seller and or the buyer exclusively, believe me, they will rake your contracts across the coals to see whether or not you fulfilled your fiduciary responsibility to the seller. If I represent the seller and Becky Peppers brings me the buyer, what is my responsibility to the buyer?
Disclose anything about the property that has to be disclosed.
That's pretty much right. It's honest and good faith dealing. An honest and good faith dealing means I'm going to let the buyer know anything and everything that pertains to the transaction, with the exception of, in quotes, anything that is financially material to the seller. So I can't tell the buyer, hey, buyer's agent, hey, bring me an offer for $400, even though it's listed for $450, I'll get it accepted for you. I can't disclose what the seller's financial statuses are, that kind of stuff. Once the contract's entered into, you still have the same responsibilities, but the contract will, in and of itself, speak for itself. That's why it's very important it's difficult to be a dual agent. How can you have a fiduciary responsibility to two people? It's sort of an oxymoron, isn't it? When you really stop to think about it. That's why if you represent somebody as a dual agent, you better have your act together, because if something goes wrong in the transaction, you're going to be held to the highest level. But go ahead.
Why is the file not being reviewed till after it was closed?
I'm sorry?
How come the file wasn't being reviewed till after it was closed?
Well, we still have an issue, and Mark can speak to this as the new broker. We still have an issue where agents just don't like to turn their files in until 2 days before you close. You know, I only review a couple sets of files. But it's like, oh, can you review this for me? We want table funding that recorded 2 days ago. Or can you review this? It's supposed to record tomorrow.
Well, then they just don't release it, I guess.
How many emails do we get, Mark? Oh, you
Daily
didn't
or weekly?
you didn't get to it. Can I call Mark and have Mark review it? You know, you didn't get to it. Now I can't get paid to him. I mean, it just goes on and on. But so agency is very, very important. So let's talk about dual agents for a second. The other thing that you really want to pay attention to is if I have the listing and Roger takes and brings me an offer, we both work for Connect, that is what? Dual agency. So what do the two of us, being two separate bodies, have as a responsibility to the buyer and the seller?
Full disclosure to both.
Use the nasty word. Fiduciary responsibility. So it does not make any difference that it's Roger and it's me, because Roger's telling the buyer, I'm going to take care of you. We both have a fiduciary responsibility to both the buyer and the seller. Any questions on that? Does that make any sense to you? Okay. So let's go back to agency. I am going to meet with the seller to take the listing. When am I supposed to have my first agency piece of paper signed?
At that time.
That day,
I'm sorry?
at that time.
At that time. What if I get a phone call from Mark and he says, I want you to come over and bring me comps and discuss the listing of my house?
That's a big one of them at that time.
Bingo. The first available opportunity when it is more than a casual meeting. First available opportunity when it is more than a casual meeting. If you meet a buyer, and I know this isn't done, but I'm just telling you, because if there's a problem, that's the question that's going to get asked. So it's really smart to pay attention to it. If you have a buyer and they call you on the phone and you start talking and they say, hey, can you come and show me property? And they start asking questions. The minute you meet them on that property, you have created an agency relationship. So wouldn't it be really smart to provide them a form as it required by the Civil Code and have them sign off on it saying, I understand what agency is.
So how many people do that?
They don't, Becky, and that's,
You do it?
you know,
Wow, I'm surprised
Yeah.
everybody signed
I,
it.
once I get past the phone call,
Disclosure that
I
explains
do
it
it.
to them, and it's for the consumer's benefit, and that's why the law has it that way, and it's just an easy way to establish where you stand with somebody, and where the sign out front, that person is working for the seller, and you're, either if it's a Connect listing, to say that then you'd be under a dual agency, but if it's another one, to explain that person is working on behalf of the seller, that person's gonna get pay you, because some people don't understand how we get paid. They think it might somehow come out of their situation, so it's an easy way to bring that up. It's, it only takes a few minutes, and it's a good way to set things off.
So, and I know that most agents don't do it that way, but I'm telling you, it's really smart that once you sit down with them, that you need to. I went on and agencies apply to leases that are more than 1 year. So like I met with some people Tuesday morning, I was talking to a couple people in here, I'm having a problem with the wife, so I may not take the property to manage. But when I went back the second time to meet with them, one of the first things I had them sign was an agency agreement. Because agency applies, because on a lease, I represent the owner only, period, end of story. So the tenant needs to know that they have no representation in the lease. So if they want representation, they better go see an attorney, because I don't represent them. So agency is broken down into disclosure and confirmation. So as a listing agent, first available opportunity, same thing with the buyer. First available opportunity, that's beyond casual contact. That is disclosure. Also required by law, prior to, read my lips, and concurrent with entering into a contract, you have to confirm for the seller and or the buyer the agency relationship that's going to exist for that contract. Okay? In our case, we confirm on the RPA on the first page, right? So let's go back to the forms. Listing agent is now going to have two things in their file. They're going to have the original agency that they got signed when they took the listing. Then at the time they get the contract, they are going to take and have an agency confirmation that is signed by the buyers, by the selling agent with the seller's signature down below. In the old days, those were all separate forms. The buyer's agent is going to have an agency disclosure signed with the buyers. And now, under the new law, you are allowed to use that in conjunction with the form that has the seller's signature on the bottom. So you can send that in. It'd be really smart if the signature on the agency was some date prior to the date of the contract. So if I'm writing the contract on, what's the date? March the 14th, the 13th, whatever it is, I probably made sense that I was showing property to the buyers a week or two ago,
At least.
you know, so it'd be really smart. I don't know you, ma'am.
Wendy Williams,
Hi, Wendy, how are you?
5 days.
So it'd be really smart, as Wendy says, to have had that signed like a week or two ago, when you started showing them property and discussing terms and conditions and stuff. So that way you have some information on dates. Because one of the issues that comes up, I have one on my desk right now, was they never told me that before I bought the house. They never disclosed that to me. And so the minute that happens, what they start looking for is, when did you establish your agency contract with the buyer?
Is there any limit on the time frame of the date? Like if you started a year ago, like we have with some people?
Yeah, it's still disclosure. And they have a really good thing on CAR. You want to go pull it all off. And it's really interesting. If you go through and you read this thing, or I've got a copy, you want to make a copy of it, it keeps referring back to California Civil Code. You gotta give it as disclosure prior to California Civil Code, subparagraph, blah, blah. You need confirmation, California Civil Code, blah, blah, blah. So you go to the RPA, and you go to the residential purchase agreement, and you are a listing agent, and you get a contract in, and in paragraph, I think it's 3, where it looks for agent confirmation, and the wrong box is checked. Let's say, for instance, it's Connect, and Dave Sirsi shows that he's representing, Connect is representing the seller, and Connect is representing the buyer. What should you do with that?
There's a box that says both buyer and seller.
It's a
Check out.
counteroffer.
Oh, you disclose.
You
it to
counteroffer
buyers,
that
so-
back, because the box that should be checked is it's dual agency. Connect is representing seller and buyer. Or if you get it back, you get one from Lyons Real Estate, and it shows nothing's checked. There's no box checked. That's a counteroffer. There's no confirmation. And when I do the RPA class, what I'm telling you, there's about 5 or 6 statutory requirements in the RPA that are required by Civil Code that we keep screwing up all the time. Confirmation is one of those. And, you know, everybody glosses over it, but it's one of those things that comes into really heavy if you have any kinds of an issue with a contract.
Sir,
That's probably the second or the third place that DRE goes. They go to the date of the contract. I can tell you these three for sure. They go to the back page for the, actually four. They go to the back page to see when the contract was signed. Then they go to see when escrow confirmed receipt of the contract, because that's tied to a statutory requirement, I think it's in paragraph 18, where you're incorporating the terms of the contract into escrow, and that's mutually bilateral instructions from seller and buyer. That's statutory, that's under California law below. The third thing they go to after they get that is they go to earnest money deposit. They want to see if the money was put into escrow at a reasonable time. Contract calls for how many days? 3. So should it get in there 14 days later?
No.
If you're a listing agent and it's not in there on the 4th day, what are you supposed to do?
Cancel.
Cancel the contract.
Notice to perform,
Yeah.
in writing.
you can also specify the timeline, though, right?
Well, yeah, but if you don't specify a timeline, the default is 3 days.
But can't you cancel
Yeah.
it if you have a lot of other good buyers behind you?
You have the right to cancel if it's not in. That makes the contract voidable, yes. Voidable.
What about
Can make
now
it voidable.
on the bank or on the short sales where you have a 45 days, so you're not necessarily putting your deposit in because you're waiting
We'll get
for
to
the
that in a second.
Okay.
Then number 4 is they check on agency. Those are the first 4 places when they audit your file. She sits down and goes bing, 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 bing. Bing, 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 bing. And if she finds that missing in one of your files, she will pull up your name. She'll pull up every file that you've got, because I've watched her, and she'll say, Mark Lehman. Bing, 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 bing. Here's it's done it twice. This one's okay. This is okay. Number 5, no. 6 is okay. 7, no. 8, no. 9, no. She prints out all those files and she starts digging. That's just a fact of life. I've sat there and watched her. So, short sale agreements on deposits. Yeah, 45 days. So this is why on short sales, it's so important. On a short sale agreement, short sale addendum, what does it say? It says, upon receipt of the short sale approval letter, what are you supposed to do?
put the money in the
Buyer
buyer.
and then
Wait,
sign-
before the buyer,
seller to sign the letter.
the first sentence in that paragraph, I forget which one it is, says to provide a copy to seller for seller's approval. It doesn't say within 1 day, 2 days, or 5 days. It's just a blanket statement. So it's really smart to get the seller's approval. Then number 2, what does it say? Within, well, actually it does. It says within 3 days or whatever for the seller to sign. 3 days or whatever. Then the next paragraph is to provide buyer a copy. So it's really smart to get the buyer to sign off on that thing. But let me go to the third thing with that, since I'm there. If there's a change to terms and contracts outside of commissions, what are you supposed to do?
Put it in a counter.
And agents aren't doing that. There's trouble in River City out there. You need to counter it. That constitutes a counter. The short sale approval letter from the bank does not constitute a counter. That is an offer from the bank to the party, the seller, on the terms that he may elect to sell his house to Kathy under. The contract's between Kathy and the seller. So the seller needs to now take those terms off that letter, and it's really smart on the counter to put pursuant to approval letter attached or something, and send that over to Kathy for Kathy's buyers to sign.
So the bank says they won't honor the home inspection or the home warranty, then that's a counter right there.
Yeah, it is.
I would counter it. So does that make any sense?
That's
So
what happens a lot.
then go back to the top of page 2 in the short sale addendum. On page 2 of the short sale addendum, there's a little box that talks about earnest money deposits. If you write an offer on one of my properties, I have an addendum to the short sale that says that the short sale agreement must be for 90 days. It must be a hard copy signature. Oh, by the way, on paragraph whatever it is at the top of page 2, the little box must be checked. Earnest money must be deposited into escrow. And I have another paragraph on there that says if the buyer walks before the seller's contingency period, it's considered unilateral breach of contract and liquidated damages may be released to the seller.
Now, can the seller legally, because of a short sale, knowing that they are not allowed to make a dime off of the seller's
Yes.
They have a
property,
deposit as a damage.
they
Yeah.
can still have the
That's a
deposit?
damage.
I've never had that issue, but I'm just curious.
And if you're a listing agent, it's really smart to do that. One of the things that's happening, I was talking to Dave Frinsnick, who's an attorney I work with down in Wilkie and Flory. It is their belief that we're going to see a whole rash of lawsuits start coming out of short sales and this foreclosure process we've been going through. And a lot of them are going to be hinged around misrepresentation and fraud by agents. Because agents are out there saying they're short sale,
Specialists.
short sale
Experts.
experts. You know? So what's your qualification? You took a class and they gave you some letters behind your name. So you need to be able, if you do that, you need to be able to defend the fact that you are just so tuned in. And I can tell you what, somebody like Dave Frinsnick will get an expert witness up there from a bank that'll rip you apart. So, you know, I'm not really excited about putting short sale specialists behind my name. But here's the key that you have to be really careful of. You need to make sure that you properly represent your buyer and your seller. If you have the seller, especially on the selling side, if you don't do a lot of transactions, you need to go to somebody, and you know, I don't endorse anybody specifically, but you know, Megan LaHare does hundreds of these things. You got Lori Frey, I mean, you've got a whole bunch of transaction coordinators out there that are handling this stuff every day. They know who to call, they know what vice president they can call. If they talk to Joe Schmidt, that's not giving them the answer, they pick up the phone and they call the vice president because I've talked to them before. So to properly represent your seller, you really need to go have the right resource for them in the short sale. And you know, it's a pain in the butt to write a check for $500 or $600 or $1,000, whatever it is, on whoever you're using. But I'll tell you what, I don't do my own. I have a third-party broker. For me, I don't want an agent. I don't want somebody who's a TC at home that's not licensed. I have a broker who's licensed and insured doing my transaction coordinating on that, because if crap hits the fan, I've got somebody who has the experience. She's got a broker's license. She's insured. She's done hundreds of them, and guess what? I have built a mini wall between me and the next level. You know, I know that sounds selfish, but that's really a smart thing to do. But Dave says what's going to happen is that we're misrepresenting stuff. If you're a listing agent, one of the ways to protect your seller is to make sure that your seller instructs through the SSA or an addendum to the contract that the buyer puts money in during the contingency period. Because that's no different than a buyer buying a house and putting their earnest money deposit into the deposit during their investigation period, right? Because that will tie the buyer into that short sale. Because if they walk during that contingency period, to my knowledge, there's nothing in that short sale agreement that gives the buyer the right to walk until such time as they're prevented with a short sale approval letter. And then a lot of the short sale guys out there have addendums like I do that's real specific that says if you do walk, it's a unilateral breach and you're giving up your earnest money deposit. Because how many of you have had buyers call you, I'm going to raise my hand, that says, I'm in contract, but I'm looking for a good deal, and I saw your listing on Kiwani and wanted to know if it was still available. Well, who are you working with? I'm working with Jane Smith from, this is on this phone call yesterday, working with Jane Smith from Keller Williams. Well, would you have Jane write the offer for you? She can show you the property. Well, we're actually in contract on another house. It's a short sale, but this is a little bit less in a better neighborhood. We like it more. Could you show it to us?
Oh, no.
You know? And so if that buyer was tied into the other contract with the earnest money deposit in escrow and unilaterally walked, the seller would potentially have the right to claim the earnest money deposit. So back to agency for 1 minute. Don't forget your question, Betty. So we all understand agency and the importance of it, right? And you all understand that the first page of the RPA is a statutory requirement on agency confirmation. Really, really important. And when you start thinking about double lending, sit down and ask yourself, are you capable of meeting the fiduciary requirements to both the seller and buyer at the same time, or is it really smart to get a 35% referral fee and hand that buyer to somebody else, preferably outside of Connect? Mark doesn't, you know, and if Dave Boatner's liking this, he probably won't like that either, but dual agency is especially when it comes to a short sale and bank-owned properties. Bank-owned properties, I'd say, would be item number 2. But dual agency right now, inside of a short sale, is becoming hot, hot, hot topic. Very hot topic. Any questions? Betty, you had one.
It wasn't a question, it was a statement. I'm in contract right now with Dana Miller on the listing I have over on Fairway 2, and she wrote right in the contract that her client would put the deposit in escrow, and that they would not look at any other property. So that might be a way to.
But if you're the listing agent and you want to protect your seller, do up an addendum. I'm happy to send you a copy of mine that you can look at and copy if you want. That is a requirement, and it says, don't even submit your offer to me on my short sale unless you meet these 10 things.
10?
Yeah,
10?
I've got 10 things on it.
Wow. I want.
Yeah, I think we all want a
I
copy
think
of
so
it.
too.
Okay, I'll send it to Mark to send out.
So all these selling or listing agents right now that are putting out properties and having a 2-day open house or whatever offers be presented on the 3rd day, or even 1 day or 2 days, they're not really doing their fiduciary duty, in my opinion, because you're not giving a chance to everybody get in there and take highest and best offer. They're
Well,
like boom, boom, and then
You know, I argued that with MLS the other day because I was on the board with somebody down at the Sacramento Board of Realtors on another issue, and we were talking about that. First of all, the board can't stop that. The relationship and the responsibility on the listing is between the listing broker, Mr. Mark, or Mr. Lyons, or whoever's Wayne Hall for KW, regardless of who his agents are, and the responsibility to the seller. Here is the issue. If we were in the old market where you had an open house on Sunday from 12 to 3 and you had 3 or 4 people through, that's probably a really good argument. You're not properly representing the seller, right?
Right.
A property I wrote an offer on 2 weeks ago that we lost on, my clients wrote the full offer for $439.9 on Saturday, which was the second day it was in the computer. I got a phone call from the listing agent with ERA up in El Dorado Hills, who I happen to know, says, hey Dave, I'm really sorry, sellers won't sign your contract, they won't have an open house tomorrow from 12 to 4. And they just told me about it. So, okay. So they had an open house from 12 to 4. They couldn't even begin to tell us how many people came through because it was like non-stop. They received over 17 offers. There was our offer and 3 more that were at list price or higher. The property sold in the $465 range, I am told, all cash. And the buyer had enough cash on their verification of funds to quote the other agent, they could have bought 2 or 3 of these and it wouldn't have hurt them.
We're scary.
So what happens is in the old days, where you had an open house and you had limited traffic, yeah. But an open house, is anybody aware of open houses today that, I mean, they're parked down the street. My clients call me to meet them on Saturday at 1 o'clock. I mean, you know, there's people, if it was here, they're parked down on Sunrise already walking with their clients.
I did that on Sunday. There's
Yeah.
So my question is, you're a buyer's agent, and you've got 3 or 4 clients that are buying, and there's one open house. How do you juggle them all?
They're all that same
That's
price
why
range?
you
One Saturday or
have,
Sunday.
that is why you have the form that is called
Your
the right
DA.
to represent more than one seller or
Yeah,
buyer.
that's your
Number-
DA.
That's the purpose of that. Number 2, my opinion is, and my practice is, you have to have your standard of practice. Because I've been in these markets before. And what you have to say is, you know what, Betty, I'm working with 3 or 4 buyers right now. They're all in your general price range from $250,000 to $300,000. I have all of you on a drip system. So you're all getting the information. And I will show all of you the properties. Now keep in mind that I don't have the right to present to you what my other buyers would offer on that house. Nor do I have the right to ask the listing agent what the sellers would take and tell you what those numbers are. So I'll show you the properties. I'll give you the comps, which I have been doing, folks, since 1981 when they were done by hand. I will give you the comps of what that house is worth today.
On a stone tablet?
Huh? They were on a stone tablet. Hey, you know what? I have my stone tablet and my boots that have horsemen are on them still up in the attic. No, that's true. You know? Don't you laugh, Betty. You were doing it before I was. Give them, and I'll give you the comps, and then you decide on what you want to write the offer for. If they say, well, you know, the house is listed at $250, do you think $270 will go? Then you have to have in your own mind whether or not you're being honest with them or not, and you might say, you know what, I don't think $270 will go. You're probably going to have to be $285 or $290 for it.
I'm hearing a lot of investment companies are offering at least 15% over.
Over asking price.
Oh, yeah.
So, I mean, it's so important. You've heard me say this over and over and over again. Standard of practice. If I get on the phone and call Kathy's clients, if I call her last 30 buyers that she's had, and I ask them the same 10 questions, I should get the same 9 out of 10 answers. If your standard of practice is how you do business, how you represent yourself as a professional, everybody that anybody would talk to that you've dealt with should be giving them the same answer. Hey, when Steve sat down with me on my listing appointment, this is what he said, this is what he did. He had me sign this stuff, you know. And you've all heard my phrase, and everybody laughs. But like I took a listing 2 days ago, he was a referral. We sat down, ex-Marine, so we started bonding because he's an ex-Marine. I told him I'd work with him anyway because I was ex-Army. Marine Corps was okay, you know, I'd accept that, it was all right. And so we sat down at the table and we were going over comps. I said, well, before we ever get started, here's something you need to understand. I'm not an attorney or CPA. I make no representations. Guaranteed warranted, express or implied. And I can't repeat what he said because it was a Marine talk.
X-rays.
And he laughed about it. But you know, every one of my clients, that sticks in their mind like that. That's one of the first things I say to them is, hey, anything that we talk about, any advice that I give you is based on my broker knowledge. And I like to think I've got more than the usual guy. If your attorney or CPA says something different than what I tell you, have them call me so I can talk to them. I want to understand what I'm telling you, why it's wrong and how it's wrong. Because that's how I learn. So, does that help you guys at all?
Absolutely.
Yes. But see that one little thing, agency. Agency. It's sort of like somebody just whispering in your ear. Agency. You know?
We should carry
And away it
this all the
goes.
time.
Kathy.
Question, when we were talking about the, when somebody is giving a time frame, which I actually have one right now,
Right.
one of my listings, but it's 10 days, you know, it's a normal sell. But it also states, I believe, and I do this, and it's in there right now, and it's loaded up to my MLS, assign sayings per seller's request, all offers to be presented and assigned, and it's in there so they can see it's not just me saying it, but it actually is
In the remarks.
Repeat that to
in
me
the
again.
remarks.
You lost me someplace.
Okay, sorry. When you do that, you know, allowing so many days to
Present
keep
offers?
it before presenting the offer.
Oh, yes.
Yes, that you should also have them sign, you know, stating that fact.
Yes.
And I uploaded that.
Absolutely. In fact,
MLS system showing
Yep.
it is there, and that
And-
it's not just me making up a number
and you can do that in an addendum, or you can do that on your listing agreement. Like right now, on the property that I just listed, I have an addendum signed by my seller saying that I may receive offers prior to being entered into MLS. that the offers may be equal to or higher than what current market value is. And that if he wants to be put on MLS, that his right and choice, but I will present all offers to him. He signed off on it. But, you know, we've already got 3 offers and I don't even have an MLS yet.
Yeah, good one.
So my guess is it's not gonna go into MLS, because the offers are really good and they're all cash, so.
Yeah, there's one yesterday. I was going to show a property yesterday. It went in MLS in the morning, and we were going to show it in the afternoon, and it went pending like 2 hours later. I was like, and it's way below market. So I'm like, I think something's a little, you know.
Probably went way up.
Yeah.
So are there any other questions?
No, we
You
had to
guys
buy
all
it
have my
before
phone
we
number?
entered.
You know,
I have
feel
a
free
question.
to yell at me with anything.
Well, a lot of times, you know, when they post seller instructions in the additional documents section in the MLS, a lot of times it's the agent's protocol, which he wants to follow, which he gets his client to sign. You were just talking about mode of operation
Yeah.
or whatever. And, you know, I don't think the sellers really would come up with those terms on their own
Okay.
without a little coaching.
Yeah.
So
So,
keep in mind, if I take your listing,
right?
under agency, what's my responsibility to you?
Fiduciary.
The nasty word,
Fiduciary.
fiduciary.
Yeah.
So will I put together an addendum and hand it to my seller and tell them, hey, based on my experience in trying to make sure that you're protected in the MLS world and escrow, these are terms that you may want to require along? That's part of my fiduciary responsibility, right?
Yeah.
In fact, one of the offers I got back on my listing that I want to take, I never got to post my addendum. So I called the agent this morning and shot the addendum over and said, guess what? I need an addendum to your contract, going through these terms and making sure they're incorporated into your offer. Or I can counter you, one of the two. But I'm not putting you in escrow without my conditions being met. So, yeah, and that's a good question. But keep in mind, that's our fiduciary responsibility. That's just like one of the things that you hear from buyers. And I heard this the other day, and I had to walk away because I'd get at my soapbox. I heard an agent say to somebody, don't worry about it, we'll just offer $50,000 over. It's not going to appraise for that anyway. Your offer is subject to, I know, doesn't that just make you, makes my knees, you know, I sort of wet my pants, you know, and it's not going to appraise for that anyway, so when it comes back, it's subject to appraisal.
And so then what if the
And
bank
guess
won't
what?
give a loan because it didn't
I've
appraise?
done a couple of those this past year. I let my buyers know in writing that if it comes back at appraised value, you've just bought a house. And guess what?
They bought a house.
They bought a house.
Appraisals are coming in.
Don't ever represent to write an offer at X, hoping that the appraisal is going to come in at B.
Well, the way this market is going, that B is going
Yeah,
up.
I was just
Yeah.
saying,
They're going to be
Yeah.
up probably.
one came in.
So,
100.
any other questions?
Yeah,
And
that
I'm going to
one.
let Mark do his RPA
Okay.
stuff. Hopefully that stuff was helpful.
No way.
Just based on, you know, I've got boots on the street just like you guys. So, okay?
Can't believe that thing closed.
Thank you very much for your time.
Thanks, Dave. Appreciate it. So I'm going to go through just a couple of quick things here. I know we're going to put on a longer class, probably the first, I think you said the first weekend in April.
First week in April.
Dave's going to put on a longer class on the RPA, and I'll make sure to send out the invite to everybody.
The
But
whole
I'm just going to.
RPA then?
What?
You're gonna go through the whole RPA?
Actually, with the name of the, may I, Mark, for a minute?
Yeah, absolutely.
Yeah, share this with your friends. The name of my class is Highlights and Hotspots. So I'm not going to go through the RPA and tell you what to put in every little block. But I will give you a form that's been filled out by myself and probably will get updated based on some stuff I get from Mark. Because there are things that you need to address, period. There are hotspots because those items are required by statute. They're not a choice. And they're a hotspot because someplace else in the RPA it says, oh, by the way, stupid, you need this to fulfill the requirements of this. So that's what that class is all about. I think it's a pretty good class. So spread the word. Let's fill the place
Are
up.
you getting it first week of April?
Yes.
Yeah,
Tape
we'll-
it, so
we'll
then
tape
it'll
it,
go
yep.
in the back.
Yep, that'll be on video.
Good.
First, I think we're planning on first Thursday in
Yes.
April, but we'll definitely send out confirmation. So I'm just going to take a couple quick minutes to let you know on a few things that I thought were interesting from the class on Tuesday. Hopefully this is all review, but we'll see. maybe some of you weren't aware of it. When you're talking business days or calendar days on the RPA, what, as far as the escrow, how many days after acceptance? Is that business days or calendar days? Does everybody know that? Calendar days, yeah. Are there, how about time periods like inspection contingency periods and all that? Calendar days. Is there anything in here that is not calendar days, it's business days?
Earnest money deposit.
Yeah, earnest money deposit.
Yeah.
So that's the only thing on here that's business days. Now, as far as calendar days for the time periods, was everybody aware that those periods cannot end on a weekend or a holiday?
Would you run that by, would you say that again?
So your inspection period and your escrow, close of escrow, none of those periods can end on
A weekend?
a weekend or a holiday. It
Yeah,
always
you
jumps
can't
to the
close
next,
or-
the following day. So I thought that was interesting.
Does it jump to the next day or a Saturday to the day precedent and Sunday to the day after?
My understanding was it jumps to the next
They
day.
say don't do it.
Huh?
I think it's a don't do it. You better count
Yeah.
your days out and make sure where it ends.
Yeah.
And
That's a
actually
smart
close.
thing.
Yeah, yeah, exactly. Let's see. We've been.
Well, I'll
Yeah.
wait until the end. but
Oh.
I'll make a statement after.
Oh, go ahead. Go ahead.
No, when you're all done.
Okay. We've talked a lot about on paragraph 3 in the loan section, putting in the interest rate and points and all that. What Gov told us is if you put in the loan details, that is good for the seller, bad for the buyer. Because you put the loan details in there, and then if that buyer is able to get that loan, then they can't cancel and say, oh, I couldn't get the loan. Whereas if you leave it blank, you're representing the buyer, then the buyer can cancel anytime before they've removed contingencies and say, well, I can't get the loan. So,
Wow. I've always been told to put it higher than,
Yeah.
yeah,
but not leave it blank.
yeah, yeah, and that's how I always taught as
Yeah.
well. So I thought that was pretty interesting.
I thought no blanks were supposed to be left empty.
What's that?
I thought no blanks were supposed to be left empty.
Oh,
Yeah,
there's
and
lots
that's
of
what
blanks.
that's what we've been preaching as well. But he said if you leave it blank, that's good for your buyer, but bad for the seller. So if
Is
you're
that-
representing
is
the
a
listing
lawyer
agent,
I've been
talking,
counted
or
on
is that
that.
this is the guy that wrote
I wanna see the rate on there.
RPA,
okay.
like made it for the California Association of Realtors. So
So if you're the listing
I'm
agent, make sure you counter
talking
back
about
the
our
blanks.
safety liabilities too, because, we don't want.
And your
to start
pre-approval
with
letter
that.
doesn't show the rate on there.
yeah,
That way, they're tied to the lower rate.
yeah. So
that
if you
lender
get
provided, right?
That's right.
If you are the listing agent, shame on you if you don't counter back a blank paragraph 3.
Wow.
So this time of when you put in against multi-offers, is it good for you as a buyer representative to leave that blank? Probably not. Your offer's not gonna get accepted. So,
right,
I mean, if you're,
Yeah,
it's
that's-
got up against a good listing agent.
yeah, exactly.
Okay, but go back to that. Eric brought up a good thing. So if you have a fiduciary responsibility to the buyer, what should you be telling the buyer before you put something in there?
To leave it blank. I mean, according
You
to
need
that.
to
now-
explain what Mark just talked about.
Right.
Yeah.
Tell
When you go
them
through the contract, you know what, buyer, we have an option to leave this blank because you're not tied into those loan terms. It gives you an applicable out. Or, because there's multiple offers, we want to show that you're serious and that, we're going to fill it in. What would you instruct me to do? Again, you need to create a standard of practice for that. I'm sorry.
Yeah,
Keep going.
no, you're exactly right.
But yeah.
It's the same thing with the box in there that says, something to do with, loan contingency shall remain in effect until the loan is funded. Try and float that to a short sale
Multiple offers.
or
Yeah.
a REO, ain't gonna fly.
Exactly. Yeah, so just make sure that you inform your buyers of that, checking that box is the best way to protect them, but it's probably not the best way to get your offer accepted right now, in this market at least. Let's see. Another thing that he mentioned that's been a hot spot is if you write in an offer and say it's all cash, and then your buyers aren't able to get cash, or they decide they want to try and get a loan instead, make sure you get that in writing as a counteroffer or an addendum. He told us about a case where they did that. The sellers accepted it because it was a cash offer. They accepted it over a higher offer that was a loan. Buyer went and did a loan instead. Didn't tell the sellers at all, and the sellers went back and sued them for the difference and won.
Wow. Did they win?
Yeah,
Yeah,
they won.
absolutely.
They won, got the difference, and I don't know if it damages or not, but either way.
And what we're talking about that, if you are a listing agent and you get an offer that has all cash box checked, and somebody also has terms in loans, you counter that back out. It's either a cash offer or it has the loans. Now, when I talk to Guff, what he says is, again, good for the buyer, bad for the seller. If all cash is checked, that's great for the seller, bad for the buyer. The strongest offer you can get is all cash with that box checked, and that takes precedence over the rest of the contract. So if you get a contract that has loan terms in it and that box is checked, the way he wrote the contract is that means that it's all cash. However, if you have people who want to litigate it, that still becomes an issue for them to fight. And so we should know better. So what we need to do is counter that stuff back out. And you can leave the buyer with the option that says something to the effect, hey, seller acknowledges that buyer may want to attempt to get a loan, and buyer can have a loan prior to the close of escrow. The seller will cooperate with it. However, this is considered a cash offer, and buyer is hereby informed that he is expected to close with cash at close of escrow.
Don't you ask for a proof of funds? The proof of funds too, not just for the deposit, but also
Well, yeah, that's the other thing that we miss all the time. I'm sure that Mark sees them on the contracts he reviews. It has proof of funds, and there's never proof of funds. If you're a listing agent, it says proof of funds in 7 days. When are you supposed to have proof of funds? 7 days. What are we doing getting proof of funds on the 29th day?
You're supposed to send it with the offer, I
Yeah, you
thought.
want it, because why would you tie up a contract if you don't? I'd say, show me the bank statement. so we
Especially if
can
you're
know
getting
that.
17 other offers. Why do you accept an offer without?
With all cash with no proof.
Yep, exactly. Okay, so paragraph 4 on title policy. Who pays for that? It's negotiable, right? If it's decided it's going to be split 50-50, who chooses that title policy?
Buyer.
Buyer.
Seller. Is
Okay.
it? No, buyer does. But
No, the
se-
buyer
well,
pays any amount they're allowed to choose.
Yep.
Seller can
That's exactly right.
direct if they want to pick up all the costs.
Yep.
okay, so
But
now
what
you
if
see a
the
lot of
buyer
pre-opened escrows on the
If
seller's
the buyer
side.
agrees to any amount of the escrow title, they can direct.
They can, but they don't have to. What
They
if
they don't
the,
have
what
to.
if the buyer agrees
Agrees
Then
to
there's no
what?
problem.
to go with the,
You mean the seller
pre-open
agrees?
that the seller, and
They can agree.
they can still agree?
They
It's
can
not-
agree,
right.
but if they're picking up any of the compensation,
Right,
they're
going
allowed
over.
to direct.
You're allowed to direct, yeah.
Yeah, exactly. And I wasn't aware of that, so I thought that was pretty
Yeah.
interesting.
Okay, so all these pre-opened ones, you can basically, if you're representing the buyer, you should put seller to pay because they're already pre-opened with whatever title company.
Yeah.
And they're directed at that
Or if
point.
you
So we
really-
agree on it, then seller check that box.
Yeah, exactly.
Well,
Yeah,
times-
well,
Use your
when
common
it's such a-
sense when there's
it's
20
such
other
a
offers.
seller's
Right.
market.
We understand statute, but don't be
Yeah.
an idiot.
I know.
I don't know if you've had any experience dealing with out of area escrows and title companies, but Los Angeles, some of the ones down there
They're different
are nightmares. So I usually write in the box where it says, where it specifies title company, I'll just put local. So it's somewhere around our region,
Sure.
you know,
Yeah.
it could be any company, but
Yeah.
that way it kind of gives us a phone number rather than an 800 number.
Yeah, but that might
Getting
push
the
you
offer
out.
accepted though, because, you know, they're looking at maybe
Good.
2 offers the same, but one wants local and one doesn't.
That's
Oh,
right.
yeah,
I would put that
definitely,
in.
all that.
That would make a difference.
Every little
Yeah.
thing right now.
Or a lender who's out of the area. I don't like that either. And I don't like big banks anymore either.
A realtor out of the area.
You know what, I options, you're not getting it, and that's who you wanna go get a loan with.
How about HOAs? Has anybody dealt with HOAs lately?
Oh, right.
Yeah.
Get your letter out real
Were you
fast.
aware that they're only allowed to charge for the document preparation the amount that it costs?
No.
Yeah.
And
I wasn't aware of that either.
Yeah, because that
I
puts a
have a
big fee
question
on
there.
it. That's a $500.
But who dictates that?
Yeah, so how much
Because
is
how do you
that?
know what the actual cost is when you have, there's some that go to, you know, they, what's the name of the, where they actually have to order it through a.
IT, property.
No. For HOAs, there is actually a company that a lot of them use, and they go there to get it, and I've had to pay that for short sales. And it's expensive, it's
Yeah.
like, really?
There's some
$400?
$400 or $500 ones out there, Lincoln
Yeah.
Crossing.
And they'll just tell you, sorry, you have to pay for that.
Right.
And it doesn't cost that to print that stuff up, but it's a separate
If
company
the
that
HOA
does
is
it.
paying that much to this other company, then that's
It's a ripoff.
It's
You're
technically
kinda
what it
talking-
costs.
We didn't
but,
start the right company.
if
Kim.
they're just
I know.
they're just going to Kinko's and printing them out and then charging
I
your
know.
buyer
They are.
$500,
They
then
are.
that's technically not allowed. Although what Gov said was usually the HOAs can drag their feet, and if you put up any fight or whatever, they'll just keep delaying and basically kill your deal. So he said to just advise your buyer to pay whatever and then go after them with small claims afterwards, which I thought was
Question.
interesting. Go ahead.
One we just closed was, we were the second buyer. The first buyer had already paid for the HOA docs, $369, and the HOA would not, the title company said that we tried to transfer it, and the HOA wouldn't let them, and we had to wait 10 days to get new docs, and nothing had changed, and they charged another
Yeah,
$369.
that's Lincoln Crossing does that all the time.
Legal?
Yeah, Lincoln Crossing does that all the
I
time.
don't know how they
Is that
do it.
legal?
They charge you a
Dave?
second time. Yep.
It's
They are
legal?
specific to the buyer.
Good gracious.
Yeah, so they're making money over there.
Yeah.
So they made double on that.
The seller normally
Yeah,
does
the
pay
seller
for it.
usually
unless-
pays.
Yeah, the seller's paying for it, but the HOA makes it specific to the buyer.
I know.
Their instructions to escrow is for this escrow, typically.
Yeah.
So one of the things you can do, Betty, when they have that, you go back to escrow and ask for the escrow instructions provided by the HOA to escrow. And every once in a while, you'll find it that they'll just say,
There's
here are
no
the
given.
HOA documents.
Without a name given.
Yeah, without a name given, and then they have to allow it to be transferred. You just need to do a little digging. But if they say, here are the HOA documents for David Sirsi's purchase on Sherborne Lincoln Crossing, then it's specific to Dave Sirsi's purchase.
Okay. I just thought it was a ripoff.
You know,
It is a
you
ripoff.
It is a
It is a ripoff, but yeah. But
know,
yeah.
you can, if you want to stand
Get
up
around
and
it.
spend some time, you could probably fight it and get them to change, but.
Class action suit
That's
against
their
Lincoln Crossing
Christmas party.
HOA.
Another thing we'll probably be seeing a little bit more of as the years go by. He says if you know the seller, if you're taking a listing and you know the seller was growing marijuana in the house,
Oh, you have to disclose
he
it.
said they haven't had a test case yet in the courts, but he advised to definitely disclose that. He says you don't want to be the test case. It's a legally gray area, but when
It's
in
also
doubt,
if it was a drug
disclose.
house.
Yeah.
If it was a drug house, you have to disclose it.
Yeah. Well, if it's a drug house, you have to. Yeah, definitely. He said this one for marijuana is still
It's not been
a
tested.
gray area, but he said he advised to everybody
It's like
to.
if it's a medical
disclose.
marijuana thing, and then,
Right,
you know,
it's-
they legally can grow their
Right,
plants.
exactly.
You
Yeah,
have
but
to disclose, I've
they're-
got somebody
just make
that.
sure
I'm not listening to your house, Laura.
The greenhouse.
Yeah, there are properties up in El Dorado Hills where they're actually growing marijuana in the basement, and the agents aren't disclosing it.
Grow lights.
That's what he's talking to.
Wow.
And when you go through the houses, if you know, it goes back to the AVID again, folks, you're responsible for a visual inspection. If you're walking around the house and there's a normal door, you know, the 29-odd-6 door, if it goes under the house, it'd be really smart just to open it, look under the house and see what's
Smell.
going on under there. And if it's got a funny smell and there's a drip system and, you know,
Grow
you probably know
lights.
there's something going on under the house, it's not usual.
If
Just
you
put,
see the smud meter spinning around all over the house.
I actually sold one where they actually had dropped the lines in. They tapped into the lines, and the clue was when we walked into the garage, on the third car garage side, there's a stack of cables like that came down through the roof, down the wall, then went along the garage wall to to the weight-bearing wall. Mike's laughing. Going to the weight-bearing wall, then went to the weight-bearing wall, and I looked in. Then we went and looked into the house. I mean, they had everything down there. They had dryers and drip systems and grow lights.
Yeah, another agent pointed that out to me at a house I was looking at yesterday, and there was just a AC unit in a closet, and I thought,
Yeah.
they want to keep their clothes.
No.
And they go, no, that's a drying method if,
Takes the moisture out of the air.
something, so, anyway, so
Yeah,
I wouldn't
fair.
have known, but
Some white cellars.
now I'll be aware.
I had a house down on 27th Street, south of Broadway, probably 20 years ago, and when we went under the house, the whole underside of the house was lined with foil and there were grow lights. So they were doing it in that space like this, under the house. It was a craftsman bungalow but raised.
Wow.
I didn't disclose
How do
it.
we write that up in the list?
It was before disclosure. Well, it was the day before disclosure.
Buds are great.
Yeah, so
I
Lori,
think we were all
I've
naive
had
back
houses with
then.
like trenches dug out underneath, and I was like, where were they going?
so Laura, your inspectors are trained on this stuff, right?
Drug-producing facilities.
Potential, income potential, additional.
I don't know if that would fly into disclosure.
Go see this doctor and get your prescription, and you're good to go.
Oh my goodness.
Well, speaking of inspections, are there any inspections that are not allowed for the buyer? Are you guys aware of any exceptions the buyer can't do?
Of the house?
Mhm.
Gosh, I can't think of any.
Well, there is one that he told us about. The buyer cannot bring a county or a city inspector out to look at the house.
Oh my gosh.
I was unaware of that.
I
I wonder why that.
They can do any inspections, the buyer can do any inspection that they pay for that doesn't damage the house, except for county
County
or
or-
city inspector.
Huh.
Huh. County or city
They wouldn't come
inspector,
out
so that they could go
anyways.
brush flag on it.
No,
Yeah.
flag.
I have a question regarding that.
Yeah.
Now, the buyer can't bring or call to the property, the county or a county inspector, but the buyer during their inspection period may go to the county, request records, and pay for them on their own to verify
Right.
the building
Oh,
permits
sure.
and things.
Oh, yeah, yeah.
That's a smart.
They
I
just
think
can't
it's-
cause an inspection to
Right.
happen on the property.
Exactly.
Right.
Yeah,
So
and
what
the,
would
and
happen?
the exception to that is if you run across something and you tell the seller that you want to check, and in writing, you specify specifically what you haven't checked, and you have them come out. Because I've run across that in Loomis Basin. You make sure that it's very specific, and that's what the inspection's for, because you open a can of worms. Because in Loomis Basin right now, Placer County is looking for non-permitted add-ons. And you see all these guys in Loomis Basins where they have the 4-car garage with their Vets and Porsches parked in there, and they've got these huge man caves up above. Those are all non-permitted man caves. You don't want an inspector walking out on that property. Because you can be held liable for the damages caused.
But there again, if you sell the property at a later time, and am I not right, I don't know, then they can come back and the buyer has to pay for those not the inspection, but
You
they
just
have
disclose
to
on the
pay.
TDS or in your AVID,
But if you
you know,
didn't know.
you're not aware whether it was built with permit or not permit.
I know, but they still can come back after them if there's no permit, after the buyer.
Your job is to disclose and make them aware.
And Dave brought up the next point, which is buyer is liable for any damage or injury that happens from any inspections that they order. So if you have, what I'm seeing a lot of is people bringing out their cousins or, a nephew or somebody who knows all about houses
Oh,
and
yeah.
can do the inspection for free. The problem with that is maybe they know what to look for, but they're not going to have insurance.
No, you do it at your own risk. I
Yeah.
really strongly.
Yeah. So that's where our good friends at BPD
Well,
come in.
Yeah.
They can
No,
handle that.
whether you disclose it is totally immaterial, because here's what happens. I hire, true case, which I did not do, by the way. I hire my stepson who needs money to to go take and do the rain gutters and leaves off of a house that I have as a rental. He's not licensed, not insured. Not my employee. So none of the three. He falls off the roof and breaks the leg, and he's not, I take him to the hospital, I get him taken care of because he's our kid, right?
Yeah.
So while he's having a smoke down at the Tower Cigar Shop, wherever he goes and smokes his cigars, one of his buddies says, hey, I know you don't want to screw your dad and mom over, but you know, you can sue that owner because you were on your roof doing work on his property. You can put a claim in against his insurance and just sue his butt for $500,000. They'll settle you for $20,000 or $40,000. When you use an unlicensed person on a property, you take that risk. So never refer. There's a guy right now who I'll leave unnamed that Randy Merrifield is recommending to people to do work. He came to me because he wants to do work in our construction company. He's not licensed, and he's doing work in excess of $500. And he's telling people, Kathy, if I do the kitchen today, $500, and I could come back on Wednesday and do the bathroom for $500, and that's within the contractor's law. It is not. Contractor's law says that I may not do more than $500 work, material and labor, on a property in a 12-month period. They will overlook it if in January I did the kitchen and in October I came back and fixed the floor in the bathroom. That gets a little gray area, and they're not going to nail them for that. But to come back and do all that work within a 1 or 2 week period, and you have, if you put that guy out the property, you're liable, folks.
And then if he saws his finger off while he's cutting wood,
Yeah.
bam, city home.
I'm sorry.
No, very good.
Oh, no, come on.
Just a couple more things here. When you're doing requests for repairs, make sure you give receipts or some sort of proof of repairs being done, other than just an inspection or a visual checking out. If you're on the buyer side and you request to the seller to have something repaired on the house, just make sure you get something in writing showing that they've actually done the repairs.
Yeah, the RPA actually says that they're supposed to provide you proof of the repair.
Right.
So if the seller does the repair, he should provide you a sheet of the materials he bought, depending on what's being done, because he's held under the same standards as if he was a contractor. If it's done by a third party, you want copies of that. Provide it in writing.
Would you ask for that prior to closing escrow?
It's supposed to be provided by contractor, yeah, prior to closing escrow.
Because you guys bring up so many hot buttons.
Yeah.
Like, I've had people that called us 2 days after they moved in the house. We haven't even received payment on the warranty. They don't have air conditioning. And it's right there in the inspection that the AC was toast. And then they told me, well, no, it got fixed, it got repaired. So I'm like, great, give me the proof of repairs. I can push it through because it was repaired and it's something that happened. No repairs, no receipt from the other agent. They call the agent, we need proof of repairs. They never did it. And they have no clue that they never did it, so their buyer moves in thinking it was done. And the seller's gone, there's no money, it's a nightmare for the agents.
Well, I guess the agent probably has to
And if
pay
you're on
for
the
it.
listing side,
Happens more than I ever wanted to
make
know.
sure that you provide that too. Because that buyer can then come after the final lawsuit.
Oh, yeah.
Yeah.
About that one.
Yeah.
And here's something else to tie into what Mark's saying on that. Verification of property condition. How many, and be honest, how many of you had a request for repair, and then when you did your VOP, you wrote the word none and had the buyer sign it? Raise your hands. So that means all of you, on the verification of property condition, wrote in there that work requested per request for repair was reviewed and accepted by buyer?
Not that either.
Oh, not that either.
Uh-oh. I am excited.
You know, I see it all the time.
Yeah.
And I know Mark sees it in the contracts he reviews. There's a request for repair, there's 14 things, and the final walkthrough says it's okay. And, There's nothing in the file or in the escrow documents that show that the work was done. Remember that word fiduciary to your buyer?
But if you have receipts of the work done or the
You
clearance.
still want on the
You still wanna put
verification
it
of
on
property
there, okay.
that the work that was requested on the, that work that was per the request for
Per the
repairs
request for
dated,
repairs.
all work was reviewed and done satisfactorily to buyer.
Okay.
Because what comes back at you is, they didn't do it right, they told me the seller was gonna do it, the seller lied, nyah. You know, just standard of practice. If it's asked for, make sure it's addressed someplace prior to close of escrow.
And then the last couple of things, the arbitration clause on page
Mediation arbitration.
7. Everybody knows that's optional. He just mentioned, Gov mentioned the two differences is basically the arbitration is just cheaper, quicker, and private. But the one big negative is there's no appeals. So you can advise your buyers either way, but just let them know just the facts that it's cheaper, quicker, and private, but there's no appeals. So if you
I
do,
have a question with regards to anybody that use the digital ink, digital signing through MetroList.
yeah.
When you send a document to a client and those boxes are optional, it seems as though they are required to complete the file with digital signing.
Yeah.
So
Huh.
there becomes kind of a problem if it is an optional.
It's not, or it's not complete.
Right, it shows up as not complete if they
Yeah.
decide not to check or initial those boxes.
Yeah.
So it doesn't forward to the next person in the string.
Gotcha.
I don't know if
That's
that's
a good
been
point.
addressed or
Yeah,
not,
I don't
but
know.
most
That
people
must
sign
be-
it, but, or initially.
Right,
yeah.
right.
Maybe
Yeah, I
they
never
made
give it
that
any
res-
thought because
Maybe
my
they made that
buyers just
requirement so that you can do the digital, you know, and it's just, you can't do it unless you do that.
maybe.
Should have an optional signature.
Well, it is, I think.
It's a DocuSign.
It is listed as optional, well then it shouldn't kick it back. I mean, DocuSign, that's
Yeah, not DocuSign, it's a digital.
Yeah, I don't use it. I don't know.
I don't know. I haven't ever tried that, but that's a good point. We can check it out. And I think that was it. So I've got a couple other notes. I can shoot them all over to you guys before. But like we said, we're going to do a longer class first weekend in April, or first Thursday in April.
Thursday. I think it's the 4th.